Ever had a package or mail delivered to the wrong address? I hope it wasn't anything too valuable. In this video, I want to walk through 13 ways that your assets, your hard-earned assets, could end up in the wrong place, the wrong heirs. And these aren't rare or bizarre scenarios. I've seen it happen. Stay till the end of the video because I will provide a checklist on how you can make sure this doesn't happen to you. Wrong destination number 1. Your siblings end up with your share of your father's estate instead of your children. This is really your dad's fault, not yours. But let's all learn from it. When your father filled up the beneficiary form for his big fat IRA, he put all the names of his 3 children, and he checked off the wrong box. He checked off per capita. Per capita means each beneficiary who's alive receives an equal share of the inheritance. Per stirpis, on the other hand, means a deceased beneficiary's share passes down to their descendants equally. If my father's intention was that my share, if I'm not around, goes down to my children, he should have checked off per stirpis. Wrong destination number 2. Minors are not allowed to get their inheritance until they turn 18. Your intention is to give them a head start in college, job, life, but instead your assets ended up funding his fast cars, jet skis, parties, even fully grown adults, lottery winners. A lot of them lose their winnings in a few years, and some are even worse off. Lump sum inheritance to an 18-year-old or even a 21-year-old is not a gift. It's a setup. Unintended destination number 3. Your child's ex-spouse. So in this scenario, your child is older and is married. He has a nice inheritance from you. Now, inheritance is generally considered separate property, unless it gets co-mingled with his wife's. It doesn't take a lot. A little thing like taking a couple $1,000s from his inheritance to fund a joint vacation cruise with his wife, boom, it's no longer separate property. It's now marital property. And hopefully not, but in the event of a divorce, his wife will walk away with half of the inheritance you intended for him. Unintended destination number 4. A lot of families, especially when it comes to the elderly, likes to put their children as a joint owner in their bank account or their investment account. It makes it very convenient. The child can help you write checks, pay bills, manage your finances, but be aware of the unintended consequences. If your child is involved in a lawsuit, in a divorce, because he is a joint owner of the asset, now your asset becomes fair game to his creditors. Unintended destination number 5. One child gets everything and the other children are excluded. This is another problem with adding a child as a joint owner to your assets. If something happens to you, then your child legally becomes 100% owner of the asset. This means he could do anything he wants with the asset. He's under no legal obligation to even share it with his siblings. You have unintentionally disinherited the other siblings. You may say, oh, my child is not like that. He's fair. He'll do the right thing. I know what you mean. I have 2 delightful young adult children, very financially attuned and responsible young adults. But what if they don't end up with the sweet, wonderful partners they're dating right now, and instead end up with a future spouse or in-laws that may unduly influence them negatively? You just never know, right? Number 6, your assets could end up with your surviving spouse's children from a previous marriage, not your children. How does this happen? In a joint revocable living trust, when one partner dies, the trust, unless there's more planning done, stays revocable. This means your surviving spouse can edit and modify it any way she wishes because she's still the trustee of the trust. So she might direct your assets to her children from a previous marriage. You're fine with her directing her half of the assets to her children from a previous marriage, but to take your half of the assets and give it all to her children while your children get nothing, you'll be rolling over in your grave at this injustice. Destination number 7. Even if this was a first marriage for both of you, after you pass away, your wife could remarry. A new husband, new kids, new families. How do you feel about your assets? Not just hers, but your half of the assets also being used to support her new family. Maybe you'll be happy for her, or maybe you'll be sad that now your kids will get a lot less than what you've worked hard your whole life saving for them. Number 8 is sad. Your assets ending up with your separated but not quite divorced spouse. You're separated from your spouse and you think, oh, I will get that 401k designated beneficiary updated when the dust settles. And then the unexpected happens. Guess what? Your separated spouse gets your entire IRA because she's still on the beneficiary designation. Remember that designated beneficiaries trump wills and trusts. I emphasize the phrase not quite divorced spouse because in many states, divorced spouses, exes, are disqualified from your inheritance. However, this law does not apply to separated but not quite divorced spouses. Mistake number 9, disinheriting a child without being explicit about it. Sad to say, some children do get disinherited, whether it's because the parents had a falling out with the child or for reasons of tough love. Whatever it is, it happens. Here's the mistake. A lot of parents think that by just not mentioning the child at all in the will and the trust, it'll be very clear that they are disinheriting the child. That is not true. The child could argue in court that his parents just kind of forgot. They just, had a lapse of memory. They just forgot and sues for his share of the estate. There's actually a really good example in the Netflix series Better Call Saul. When Saul's very wealthy brother passed away, he left instructions for Saul to receive $5,000. Not because he was generous, but because he wanted to make it very clear that he did not forget Saul and that $5,000 out of his millions of estate was all he intended for Saul to get. Cold, but very clear. Number 10, your assets end up in the hands of a total stranger. How is that possible? This happens when you do not specify a backup beneficiary and there's no other close family that has survived you. So the court simply goes down the succession pecking order and locates a 7th cousin twice removed in Portugal, cousin Marika. So you've never met cousin Marika, she's never met you, she's a total stranger. Let's just hope she puts your assets to good use. Unintended destination number 11. This is more dire because you don't have any surviving family around, not even a 7th cousin Marika in Portugal. Actually, this is not an unusual situation. Family sizes have shrunk a lot, and there are a number of elderly singles in America with no beneficiaries, no families, and they feel that, oh, I don't care where my assets end up. Well, let me tell you, in a situation like that, your assets will escheat to the state. That is the vocabulary of the day, escheat. It doesn't sound nice because it doesn't have a nice meaning. It means that the state gets it all. The state gets all your assets. Okay, so you don't have any family, but is there no friend, neighbor, cause, charity that could put your money to good use? Number 12 is to give a chunk of your estate to Uncle Sam. Guys, you know Uncle Sam is not your real uncle, right? He doesn't call you on your birthday. He doesn't help you move. He doesn't send you a housewarming gift. But he's always there to collect your first paycheck out of college. When you sold your first home, he wants a share of that appreciation. When you retire, withdrawing your IRA, you're going to be passing out a third of that to Uncle Sam. And guess what? When I die, he's not going to slack off. Even though the federal estate tax exemption is very high, $15 million actually in 2026, there are all kinds of ways that Uncle Sam will be knocking my door about. The state level estate tax, that's a lot lower. In my state, Massachusetts, it's $2 million. Capital gains tax, income tax, and IRA withdrawal taxes. So do some tax planning, because otherwise that Uncle Sam will be your constant companion. All right, for those of you who are still with me, we are at number 13. What other places can your assets end up in by mistake, right? I save it for last. For a lot of you, if you do not have a revocable living trust, you will be spending your assets in the probate courts. Probate is not only stressful, slow, it takes a year to 2 years. Public, you're paying court fees, you're paying attorney fees, appraiser fees, executor fees. Wow, frankly, I was surprised myself when I was compiling this list how many wrong places my assets could end up. That's why we need a checklist, kind of like an audit, to make sure that we don't end up in the same situation. In the interest of time though, I will give you that checklist as a link below this video so that I can focus on the top 3. Number 1, for a lot of people, you're really better off setting up a revocable living trust. A trust allows more flexibility in terms of the distribution of your assets. For example, if you have young adult children, you can stagger the distribution at different ages so that they're not getting a lump sum at age 18. Another example is you can protect your share of the asset for your children while supporting your surviving spouse if she remarries or if her children from a previous marriage needs help. And a big advantage of the revocable living trust, of course, is that it avoids probate. Because as you saw, probate can get very expensive. Money that is better off going to your kids than to the probate courts. So that's number 1, setting up a revocable living trust. Number 2 is to review your designated beneficiaries frequently. Look out for exes that shouldn't be there or soon to be exes. Make sure you have backup beneficiaries. And don't forget to check the right box. Did you mean per capita, so that my share goes to my siblings? Or did you mean per stirpes, which means my share, if I'm not around, will be passed down to my children? Number 3 is not a test that you can do in an afternoon and cross it off. It's more a long-term thing, which is to have a lot of conversations with your children. Help them learn how to evaluate their friends, help them learn how to evaluate opportunities and understand better personal finance, because you can't protect them forever, right? At some point, they'll have to make their own choices. Who they're friends with, who they marry, what jobs they pursue. You're not always going to be here to protect them. So the more conversations you have with them, the wiser they'll be.